This
Before we
conference
start,
will now be
I
recorded.
see that we have attendees from the United States and from different cities of India. Thank you all for joining. Just let's give one more minute to a few more people who have said they want to join. Okay, it is 5:30 and we would like to be punctual, so we will start now, and the other members can join in as and when they are ready. We're going to repeat this session on Monday, so if anyone joins in the middle and wishes to get another opportunity to hear us out, you can join us again on Monday. So today we have Zeenat Fofalia, a senior attorney in our firm. She practiced US immigration law and is involved in hundreds of H1-B cases every year. I'm Purvi Chothani. I'm the managing partner and founder of the firm, both the firms LawQuest and the law office of Purvi Chothani. And between Zeenat and me, we have got more than 30 years, 35 years of US immigration practice. We are Indian attorneys, Indian advocates since more than 50 cumulative years. And we bring today to you some of our practical insights, and we wish to address some of the issues that you all are facing with your H1B workers in the United States just now. So this COVID-19 situation across the globe is extremely unfortunate. Nature has actually arrested us and put us in jail, as it were, but this is one jail from which none of us is in a hurry to leave, because we are more fearful of what is outside our homes than being confined to our homes. But in this situation, which is absolutely unprecedented, we have nothing even to compare to this, has really put a lot of pressure on US employers as well as employers across the globe. But today we are focusing on US employers. And they are grappling to stay profitable, to stay floating during this crisis. And one of the biggest cost centers in a business, especially for the IT sector, which is very relevant to Indian companies, is the cost of human resources, because the entire business is modeled on services. So companies are trying to balance the interests of the employees along with the interests of the business, and it's a tough place to be, and it's a tough choice for business leaders and HR to make. Today, what we are going to share with you is some of the things you all need to be alert about, and some of the steps you could possibly take to mitigate your losses or to stay afloat and not hive off a large number of your H1B workers. We're going to focus on H1B workers today. So I'm going to ask Zeenat to please kick off the discussion with the first question that we have, which is, do you have to continue to pay the LCA salary in these COVID-19 situation? And you please explain to us why this question is relevant, and then give us your views, please. Thank you.
Thank you, Purvi.
Zeenat, we can't hear you.
Okay. Thank you, Purvi, and good evening to all. Thank you for taking the time out to attend this webinar, and we really do hope that the discussions today provide clarity, as we all are facing some unique issues and tough decisions during this unprecedented time. So let me start off by addressing the question that Purvi mentioned. Does an employer need to continue to pay the LCA salary? Now, as most of you know, an H1B sponsor needs to make certain attestation on the labor condition application, which is filed and certified by the Department of Labor. One of these attestations is that the H1B employer will pay the H1B worker the higher of the prevailing wage in that geographic location, or the actual wage payable to similarly situated workers. So the simple answer to that question is yes, the employer will need to continue to pay the LCA wage. Now, in this unprecedented time, we're seeing that a large number of employees are having to work from home, or because of the nature of their work are rendered unproductive. They cannot work at the end client work site due to office shutdowns, or the nature of their work is such that they need to be physically on the ground performing the work. So what happens in such a situation? Now, under the H1B regulations, the obligation of the H1B sponsor continues to pay the stipulated wage set forth on the LCA. In certain situations, which I will touch on later in the discussion, how can the employer reduce work hours or reduce the salary? But I'm going to get to that question in a bit. But in the COVID situation, and in the context of employees having to work from home, or in situations where they are rendered unproductive, the answer is yes. The obligation of the employer continues to pay the required wages set forth on the LCA.
So before we go to the next question, I'm going to request everybody that we have muted your mics, and we've also turned off your video cameras, because we want to make sure that we don't have bandwidth issues, and as many people who join are able to at least clearly hear us and see the presenters. We do regret any inconvenience this causes, but please note that we want to address your questions. We're going to confine our presentation to about 30 to 35 minutes, and the rest of the time is all saved for questions. Please start sending your questions in the chat. You can send it to everyone if you wish, or please address them to Rupali Nayak, who's one of the organizers. If you click on the chat option, you will see that she's listed over there, and you can send her all the questions, and she will then forward them to us, to Zeenat and me as appropriate. So I request you to send your questions in the chat. You may start sending them now. And if your question is not addressed during the presentation, we will take it up at the end. Rupali, I request you to please turn off the cameras of one or two people who have recently joined, because it's distracting and it is going to take away from the bandwidth. So I request you to please do that. Okay, now, soon after we talked about LCA salaries and that employers must continue pay these salaries, we have a bit of good news for small companies. And small companies in America means, in this context, refers to companies that have got less than 500 employees. The US government under the CARES Act has announced small business loans to such companies to help them tide over these difficult times and save jobs of thousands and thousands of US workers, and that of their employees, not only US workers. So that includes H1B workers as well. This is called the Paycheck Protection Program. And the idea is to make sure that thousands of employees don't fall out of the insurance network, because if they lose their job, they lose their insurance in America. And that's a real challenge for the country and for the pressure it will put on the healthcare system and the expenses. So that's one of the reasons why they're doing it. And the other reason, I mean, there are many reasons, but these are 2-3 reasons that are relevant to employers. And the other reason is they want to make sure that employees continue to hold a job as long as possible. This is actually a blessing for small companies that employ H1B workers, because what they're going to give is 2.5 times the salary that you all have paid in a previous year, the average salary that you all have paid in the previous year, up to $10 million. So it's 2.5 times your payroll cost, and it is capped at $10 million. And the benefits are to be, and to count them, you have to count employees' salary up to $100,000. So if an employee's salary is $120,000, you have to count only up to $100,000. They're not going to protect employees beyond that salary limit. This opportunity, or this, what shall I say, this lifeline that the government has given them has already become extremely popular among small businesses. Banks like Chase Bank and Bank of America, etc., have had hordes and hordes of people, companies applying for this, and there's a lot of pressure on the system. However, it is something that small businesses should consider. And if at the end of 8 weeks they can prove that they have not terminated employees or reduced their work hours, there is an opportunity to even get that loan waived. So first of all, it is a low interest loan. And second, if you comply with certain criteria, you might even be able to get a loan waiver, which is also extremely helpful. Now I come to Zeenat with another question. She mentioned that there are situations that can affect these H1B workers. So Zeenat, in such a situation, you could ask US workers to go on furlough, that is leave without pay. Could you do that with H1B workers? And if not, um, and tell us why we can't do that. We can't hear you, Zeenat.
Sure. Thanks for the question. No, unfortunately, you cannot furlough or put H-1B workers on an unpaid leave of absence if that is required by the employer and is work related. So let's say in the COVID context, right? If there isn't enough work for an H-1B worker, or there is no work at all, and the employer wants to put the worker on a furlough or on an unpaid leave of absence, he cannot do that. The H-1B regulations require the employer to continue to pay the worker the required wages as set forth in the LCA. Now, in a situation where an H-1B worker voluntarily requests for leave, let's say he wants to go on a holiday or care for a sick relative, then in that situation alone, the H-1B sponsor is not required to continue to pay the H-1B wages. But other than that, H-1B workers cannot be furloughed or benched or put on unpaid leave on account of the employer's inability to pay the worker.
So adding to what Zeenat said, it's also the inability of the employer to give them work, because many of the IT companies in America have a business model where they deploy their staff to third-party sites, to end client sites, and because of the social distancing and stay safe, stay home directives, they are unable to go to work. Many of these companies are also unable to give these workers an opportunity to work from home due to security reasons and due to other things. And some contracts are being cancelled or suspended just because there is no business, there's no anticipated income. And that puts an additional burden on the Indian IT companies that are in the third party client side servicing business model. Um, we'll touch upon the penalties a little later, but other than that, you also have to know, you also have to remember that when we spoke about going on voluntary leave or holiday, there were certain newspaper articles, especially in the Indian press, which spoke about, yes, employees can go on voluntary leave during this period. Of course, they can go on voluntary leave during this period, but to avoid any Department of Labor audit or questioning at a later stage, it is important to document that these employees had asked for the leave in advance, preferably that is before COVID-19 hit us, or even if during COVID-19 there's an absolutely legitimate explanation of why they're asking for leave. If they are unable to give you that type of documented request, I would suggest that companies tread cautiously. And the newspaper articles also suggested that this could be used as a voluntary measure to have many of the employees go on leave. And I don't think that Department of Labor will buy that, because a few people going on leave, personally, I understand, but a large group of people going on suddenly on personal leave, that's going to be extremely hard to explain. And you could end up being slapped with back wages, penalties, and all the other things that come with violating H1B norms. So the personal leave option is got to be cautiously handled. But if these employees are sick and they themselves are victims of COVID-19, or their family is a victim of COVID-19, then yes, they could be away from work. And then whether this will be counted as sick leave, or how these days will be counted in their paycheck, will be determined by the state laws of employment. So that is something that you need to keep in mind. So, um, and yes, in the situation, if they are afflicted by COVID-19 and are unable to come to work, in that situation, again, like I said, it is to be determined by state law. How many days of it can be counted as sick leave, and how many days will be leave without pay. It is not a part of the federal law, so you'll have to check your state laws for that. Zeenat, can you help us with this question? What steps does an employer have to take if it wants to reduce H1B workers' work hours? Can
Sure.
they do it? If yes, how?
Sure. Yeah, before I get to that question, Purvi, I just wanted to add to the prior question regarding what if an employee is is affected with COVID-19. So, let's say in a situation where an employee has tested positive for COVID-19, and the employer requires him to self-isolate or quarantine, then it can be argued that it is the requirement of the employer to self-isolate and quarantine, which is why the employee could not report to work. So just wanted to, add that bit.
Yes.
And
Thank you. Yeah, that's a valid
yeah,
point.
um, so what steps does an employee have to take if it wants to reduce H1B workers' work hours? Now, typically, we've seen that H1B workers who are sponsored, particularly, by large IT companies, are for full-time employment, which is about 40 hours a week. Now, let's say in the current situation, if there isn't enough work, and the company wants to reduce the workers' hours from full time to part time, such a reduction of hours would constitute as a material change, because the number of hours, whether it's full-time employment or part-time, is typically stated on the LCA. So any reduction regarding regarding salary or work hours would largely be considered as material, in which case a new LCA would need to be filed to reflect the reduced number of hours and an accompanying H1B amendment petition.
Right. And there are a couple of other things that you all need to be cautious about when reducing the wages, because if you are an H1B dependent employer, then you still have to ensure that the salary doesn't go below 60,000 if you use that as your exemption. And also, when you do reduce your hours, you've got to make sure that the pro rata salary still meets the prevailing wage salary. So you've got to be careful about that. And if you're going to do a negotiated salary cut, which also can be possible in with the H1B workers in very limited circumstances, you've got to be careful. If you're doing a salary cut across the board for all your workers, H1B and US workers, you could negotiate a salary cut for your employees. However, even with that salary cut, you've got to be sure you're paying whatever the salary you have committed in the LCA. There's one more risk that employers face when they have this type of negotiated deal. And it's very critical to document everything and to make sure that it is very clearly said that it is done across the board and not only for the H1B workers because of lack of work or benching. Otherwise, you face a risk of an employee becoming a whistleblower and complaining about you to the Department of Labor at a later date, and then you getting hammered with a Department of Labor audit, penalties, and even disbarment from the H1B program. So yes, you can do it, but do it very, very carefully and make sure it is done across the board. What I'm going to now address is what steps does an employer have to take to terminate its obligations to pay the required wage? And I see there are a couple of questions here on the termination issue. So I hope that what I'm going to say now will address those questions. So if you want to cut your losses and stop your overheads because of salary, the cleanest and best thing for a company to do is terminate an employee. And that termination has to be effective termination. And what does that mean? That means informing the USCIS of the termination and withdrawing the H1B petition. And as a best practice, if you have individual LCAs, you must withdraw the LCA as well. However, if you've got multiple employees on a single LCA, you may not be able to do this, but make sure that the public access files of the other employees and the LCA have a note about this termination. So there is no doubt in anyone's mind if there is an audit. Now, once an employee is terminated, they're allowed to stay in the United States for a 60-day grace period, during which they can either find another job or wind up their affairs and return to their home country. It is the employer's obligation to make sure that they have return passage to their home country. Now, the tricky situation is, let's see if you're talking about H1B Indian workers. They can be terminated. They've got 60 days to leave the country. However, India is not permitting any flights to land from overseas. So how can they come into the country? So they cannot. So there is a likelihood that they might be stuck in the United States beyond the 60 days grace period that they are granted. What should employers do in this instance? In this instance, they should clearly document and say, here is your termination. We are willing to fly you back. Tell us when you find the ticket and buy the ticket for them. Whatever the cost of the ticket, first ticket out and send them out. Also, look out for government initiatives where the Indian government may arrange for special flights to fly out their nationals in different countries. We have seen that type of initiative in India. Many countries, the US, UK, Germany, Israel, Malaysia, they have all arranged for special flights to take their nationals out of India. And we are expecting a similar situation if there are crisis situations with visa holders in other countries. But countries like the United Kingdom have given an automatic extension of visas till the end of May. So if the USCIS or the Department of Labor comes out with any such relief, they will be protected. However, otherwise, before the end of the 60-day mark, they should leave the country. If for any reason the employees believe that they cannot leave the country before the 60-day mark, they should immediately file for a change of status application. They can either enroll in a university and apply for a change of status to an F1 student visa, or they can apply for change of status to a B2 tourist visa or a B1 business visa. You should do it. You should make sure that your change of status application reaches the USCIS before the end of the 60-day mark, because that is considered a timely filing and allows you to stay there until that application is decided. So the time you wait for that application to be decided, or the time that you spend there before you leave the country, will not be considered to be unlawful presence because of the timely filing. So that is something you should sensitize your employees about, because otherwise you're going to have a panic situation on your hands. Um, um, I've also been asked that if we terminate the employees, what are the options? What are the options that an employer has? The employer really has no options after their employment has been terminated. However, during that 60-day period, if things settle down and you feel that you can absorb them back, you can file another petition for these same workers. But you will need a new H1B petition for them, and they cannot start working immediately. They can only start working after the petition is approved. So on one hand, it's a very good option that you can re-employ them and file an H1B petition for them. But because premium processing has been suspended for H1B cases, it's going to take several weeks for them to be processed. And a timely H1B filing does not protect them within the country. But a timely B1, B2 filing would protect them within the country, a change of status, because that's a change of status. While in the H1B case, we are applying for an extension of status for which you need to be in legal status. So you need to be careful about that, but that is one option you have. Your salary is suspended for the 60-day period, and then you can employ them back again. Zina, did you want to add anything
Yeah,
there?
also to add to that, Purvi, like you said, there are no clear guidelines from the USCIS or the DHS in terms of, what happens if employees exceed their 60-day grace period, right? But there is strong speculation and push from AILA, the American Immigration Lawyers Association, saying that, USCIS should take a liberal and compassionate view, in this unprecedented time. So there is a good chance that if an employee ends up exceeding the 60-day grace period or falls out of status, that could potentially be forgiven, or may
That's
not,
true.
end
Yeah.
up jeopardizing his future petitions.
That's absolutely true. In fact, AILA's suit against the USCIS is asking for automatic extensions as well for certain I-129 related statuses like H, L, O, P, etc. We'll see how that judgment comes through. Um, the next question, Zeenat, is for you. If an employee starts to work from home, where does the LCA notice have to be posted, and when does it have to be posted?
Sure. Um, so now we're seeing that, again, in the current situation, a large number of employees are having to work from home due to the stay-at-home orders. Now, if an employee, typically the employee's home would not have been included in the LCA. So what happens in this situation? There are two ways this could pan out. If the employee's home location is within the same metropolitan statistical area, MSA, as his primary normal work location, then in that case, no new LCA is needed. The employee can start work from home. Just the LCA notice posting needs to be put up at his home location, and that can be done. So the Department of Labor has relaxed its guidelines. That can be done after 30 days after the employer begins work, or within a reasonable time, whichever is earlier. Now, what happens if the employee's home is outside the MSA, metropolitan statistical area, of his primary work location? Now, in such a situation, and in such a the regulations provide for what is called as short-term placement. Um, in that, so what that means is, if the work location is outside the MSA and is not included in the LCA, the employee can work for up to 30 days without having the need to file a new LCA or an H1-B amendment. Also, in certain cases, this 30 days, which is a cumulative period, this 30 days could be extended for an additional 30 days, but no more than 60 days within 1 year, provided that the employee maintains permanent ties to his primary work location, which means that he has a permanent workstation, or he has access to his primary work location, and also provided that the other terms of his employment remain the same. So in such a situation, again, to sum up, if the employee's home location is outside the MSA, the employer can avail of the short-term placement provisions, which allows the employee to work for a period of up to 30 days, and in certain cases up to 60 days, without the need to file a new LCA and an H1B amendment petition. And again, like I said, in the first scenario where the home location is within the same MSA, the LCA posting notice needs to be posted at the employee's work location, and also needs to be maintained in his public access PAF file.
So that's a some relief from the Department of Labor and some relief in the regulations also. Just one more thing, one more piece of good news I wanted to add was Zeenat said 30 days is 30 working days. So that in effect comes up to about 6 weeks. And the 60 days is also 60 working days. So that comes up to about 12 weeks. So you've got a buffer over there before you really need to file a new H1B petition. However, you've got to remember that if you've used this if you've used this temporary absence from the primary work location, if you've used any days out of it, that number of days have to be deducted from the 30 or 60 days. So you need to go back and see the itinerary of the worker, see if they've spent anytime outside the primary location, and then calculate it and then carefully calibrate that and file the petition when it is time. So we are coming to the end of the 30-minute mark, and we will also take open mic questions. Preferably, we'd like to take questions over the chat. So if you all have questions, please do send them our way. But before we wrap up, I just wanted to talk a bit about the current H1B cap situation. So the H1B cap selection this time was completely modified. And between March 1st and March 20th, employers had to do an online registration. And then between March 21st and 31st, they ran an online lottery, and the lottery results have been announced. 275,000 petitions were, 275,000 online registrations were taken, out of which 67.7% were for Indian nationals. So that's a huge number. The statistics for how many of the selected ones were Indian nationals is still not available, and I don't think they'll publish that. But what situation has now come up is that many of the companies that did file hundreds of online registrations, because they had worked for that many number and they knew that they may not get the entire number, so they were preparing for October 1st projects. And let's say a company got 100 selected out of the 300 odd that they filed. Companies now may be in a situation where they don't want to use the full 100 cases. They actually are sending back people from America. Now, what do? Can you file less than the 100 that was selected? As per the current regulations, as per the current warnings that the USCIS has given us, you cannot file less than the numbers that have been selected, except for the odd one here and there where an employee says, okay, I did want to go to America, but now I don't, or you find that he's given you a fraudulent degree or whatever. Those type of random cases, if you don't file, you will not be penalized. But otherwise, as it stands today, you will be penalized, and you will also face disbarment from the H1B program in the future. But we are hearing from the industry, from the company, that many companies are in this situation. So let's say if 4, 5, 8, 10 of the big employers, when I mean big, I mean number of cases that they use for H1Bs, the ones that file 2,000-3,000 H1B petitions, or 2,000-3,000 H1B online registration. If all of these companies decide that they cannot file the full number, then I don't know how much the Department of Labor is going to go after the companies. I also think that it's going to be that they will announce some relief before the June 30th deadline, because we have a window in which the H1B petitions have to be filed, that is between April 1st and June 30th. And if we don't, within that period, I believe strongly that they will announce some relief, because they don't have the bandwidth to audit and penalize everybody and put everyone's cases through scrutiny. So I think there will be some relief. But until then, it is our advice to clients to be prepared to file all the petitions that have been selected. Yes, it is expensive, but you can wait right up till the middle of June to file them. Keep your LCAs ready, keep everything ready. Don't file till June, because if there's a way to avoid it and the government announces some relief, then you can benefit from that. But don't wait longer than that. Okay, if there are questions, then you can send us a chat. You can send Rupali a chat request, and she will unmute your mic for you, or you can unmute it yourself and ask us. Please identify yourself. Okay, we have a question here. My son is studying in the United States, California, and will graduate with an MBA in the month of May 2020. If he does get a job, then how long is he allowed to stay, and will he get a grace period before his OPT ends? No, this situation, there is no need for a grace, because if he's graduating in May, he's going to get OPT till the end of, till May 2021. So this is not a situation in which they're going to grant any grace, because you're going to be able to take your entire 12-month period. You don't need any grace period. And getting a job at this stage today is not going to help him, because there are no H1B numbers available for him unless he's getting a job with a non-profit or a government or a research organization which are exempt from the cap restrictions. But if he is trying to get a job with the private sector in pure business because he's got an MBA degree, that's most likely what he's going to get, then he will have to wait till next April to try in the H1B lottery. And if he gets lucky, then he can convert to OPT, from OPT to H1B in October. At that time, he will have a little bit of a benefit under what is called the OPT cap gap. But we will not spend more time on this because this is not directly related to businesses. So we're more focused on business questions today and happy to take more. Okay. Yeah. Uh, what other options do employees have if they are not getting jobs? Somebody else has asked that what other options do they have? So if they can't continue in their H1B job, like I mentioned earlier, it's best to get a change of status application filed, and you should move to either F1 as a student or to H1B. Sorry, B1 as a business or B2 as a tourist. So best to file a change of status application within the 60-day grace period from losing your job. So a little bit about what India is doing. India has taken a different view in how they are protecting their workers. They have actually, under the Disaster Management Act, circulated certain advisories telling companies and governments not to terminate employees. And this this is an advisory. The way they have propagated this request is by way of an advisory, but because the advisory is under the Disaster Management Act, it has got criminal teeth and it has got sanctions and penalties as well. So they are protecting the workforce like that. Employees in the essential sector are allowed to go to work. Factories and businesses that are in the essential sector are allowed to continue business. So people in the healthcare and personal hygiene sector, pharmaceutical, banking, the stock markets, all those employers and employees are allowed to continue working. Now, there are situations where employees in these essential services are not reporting to work because of personal safety. Now, the advisory from the government is not to terminate anyone just now. But if employees are willfully not coming to work, even though they're working in an essential sector, then they can be terminated, and you can explain to the government why you should not be penalized, and you'll be fine. But other than that, any terminations, even for people on probation, even interns, you've got to be very careful about those in India. We've got another question on an H1B. Okay, in the case of an effective H1B termination, the beneficiary with an opportunity via a new petitioner files for change of employer. Once the petition is filed on normal processing, within which time window with the USCIS, provide the receipt notice given the minimal work capacity with COVID. So USCIS is running on a low staffing numbers just now. However, it's been our personal experience that they are very quick in issuing receipt notices and processing cases. In fact, we saw some unusually quick adjudications, but that doesn't mean that's going to continue because we don't know what the situation is going to be. The question is, you're asking when will you get issued the receipt notice? Now, the receipt notice may take 2-3 weeks to come, but you've got to be sure that this person can start working immediately or not. And for that question, I would suggest that you can talk to us separately. We'll be happy to address that question for you separately. Zinat, I have a question for you. Will the USCIS provide any grace period for employees who complete the 240 days after the expiry of their I-94 due to travel restrictions? We recently addressed this for one of our clients, if you remember. You need to unmute your mic, Zina.
So I'm going to address this question in the H1B extension, H1B amendment context. So let's say, an H1B extension petition has been timely filed, and there is no decision issued um, um, 204, within a period of 240 days from the date that the employee's H1B validity period ends. So what happens in this situation? So on the 241st day, the day that is the day from starting from the end of his petition H1B petition validity, the employee needs to stop working. Because he from the 241st day he loses his H1B status, but he can still continue to live in America until the time that his that the decision is issued in his case. Now, if there is a approval decision issued, then he can resume work as soon as the decision comes through. If his petition for any reason is denied, and unless it is appealed, in that case, he will need to immediately depart the US.
Yeah, because if he doesn't depart the US, he will start accruing unlawful presence. And to talk a bit about unlawful presence, if you accrue more than 6 months of unlawful presence, you get barred from entering the United States for 3 years in any visa status. And if you accrue 1 year of unlawful presence, then you get barred for 10 years. So you've got to be careful about that. And with this 240-day mark also, there is a regulation which says that if the petition is denied, the time that the I-94 expired, right up to the denial, those days will be counted with retrospective effect to determine unlawful presence. So you've got to be careful about the timing that you spend in America after the denial, if at all there's a denial. Okay. The question is, can an employee continue to remain in the US for 60 days after termination, even if the petitioner has submitted a request to withdraw the petition and has already withdrawn the LCA? The answer to this is yes. This is effective termination. What you're talking about is effective termination, and an employee can live in America for 60 days after effective termination. So effective termination for the employee will be the day on which he receives his last pay. So the day the employer says, this is it, from today onwards, you're done. So that's the day he has to start counting his 60 days. Yes, he can continue to remain there, and he can look for a new job, and the new employer can file a cap exempt H1B petition for him. Is the USCIS processing permanent residency applications currently? Approval was received. The final paperwork, including means of support, etc., was pending. This is a green card application. Permanent residency applications, if they are at the NVC, that is the National Visa Center in America, they are continuing to process them and take them to the next stage. But if you're at the consular processing stage, those services have been suspended. Unless you can show urgent and extenuating circumstances, they will not take your request or they will not process your case further. But if you do have an emergency or an extenuating circumstance, you should approach your closest consulate and embassy, and they will take it into consideration. There's another question for us. Considering current COVID-19 situation, where may we see many okay, this relates to the online registration process. Are there any chances for the remaining cases which status has submitted to change to selected because of the COVID-19 situation? Yes. So what has happened is, with the 275,000 online registrations, the ones that have been selected now appear on their USCIS portal as selected. The remaining continue to remain submitted, and about 100 are considered denied, and those are in dispute. The ALA and the petitioners have taken it up with the USCIS because there is a claim that they were wrongfully denied. So let's talk about the ones that remain in submitted status. They will remain in submitted status till the fiscal year begins on October 1st. So any cases that are not any visa numbers that become available because a selected petition was not filed will go towards these submitted applications. And yes, you may have more cases moving to selected status from submitted status. I hope I was clear. So basically, if you have got them in submitted status, let them be there, don't withdraw them, and continue to watch the space. They may get selected before October 1st. The question is from somebody would like to check, how do we determine the metropolitan statistical area radius? Should this be understood as 40 or 50 miles? Thank you. The question is about the MSA. Now, the regulation and the guidance that they have given is not really only MSA. It is actually in commutable distance, which is generally considered to be the metropolitan statistical area. However, people drive 30, 40, 50 miles in America to work at a place. So if you're not in the same MSA but within communicating distance, and that is generally considered to be up to 50 miles, you would be fine. You will still not need to do a change in you would not need to amend an LCA or a petition. I hope that answers your question. We have one before that. Can we keep employees in bench without project at our place and they have been laid off from the client? Okay, you have employees in the third party site and their project, the third party site project, has been terminated, and you're now bringing them into your offices. Yes, you can keep them there, and you can, they can come to office every day and you've got no work for them, but as long as you pay them the salary, you are complying with your H1B obligation. So you can't bench them, because that's part of your question. Benching means unproductive status without pay. You can't do that. They can be in unproductive status but with pay. Okay, I hope that answers it. My Okay, if anyone's questions remain unanswered, even if you posted it on the chat, please let us know. I'm just checking, and I think I have answered all of them. Rupali, have we missed any? Okay, I don't see that question from Ashwini, Rupali. Here it is. Okay. So the question is about biometrics and change of status, and there are no biometrics appointments being granted just now by USCIS. So how do these petitions get processed? Now, the biometrics are generally required in H4 and EAD applications, and similar. So if they have given biometrics in the past, the USCIS has indicated that they will use those biometrics. Earlier, they never used biometrics. For every application, they took biometrics again and again. But now they've announced that if they have them on file, they will use them. However, if they don't have them on file, your case is stuck. You'll have to wait till USCIS begins operations again. Now, the question that we also get from employers is, and employees is, that if they have suspended biometrics, should we pay the biometric fee when filing applications if we have given biometrics in the past? Our advice is yes, because if they resume biometrics and you're required to go for biometrics, you don't want your application to be rejected or returned because your $85 biometrics fee was not there. So if I were you, I would put the biometrics fee. And yes, unfortunately, if you don't have biometrics on file, you'll have to wait for USCIS opening. Again, somebody has asked about selected and submitted cases. So probably I was not very clear. So cases on the USCIS portal are in three statuses just now. One is submitted, next is selected, and the third is declined. If it is in selected status, you've got to file the petition between April 1st and June 30th. If it is in submitted status, please wait, because if people don't file their selected cases, your submitted case could become selected and you'll have an opportunity to file it. So you should hold on. right up till at least October 1st, because that's when they're going to either take down those cases or give us further guidance. Zina, did you have any more comments you wanted to make?
Not at this time.
Okay. Now we've got another question which says if an H1B employee is outside the United States and is unable to return to the US to file his extension petition, will the USCIS provide any relief for such employees under COVID? At the moment, no relief has been announced. Nothing has been announced. So since these people would have been counted in H1B cap before, the best thing would be to file a new H1B petition for these individuals, even if it is with the same employer. This brings to mind another question. This brings to mind another question, which is that if you have employees on H1B who are in India to either get their visas renewed or to have come here for some family reason and are unable to travel back, it's a circumstance beyond their control. Can they continue to render services to your company in, and do you have to continue to pay them H1B salary? They can continue to render services to your company in the United States. But if you don't want to pay them the H1B salary, then you've still got to do the termination process within the United States. So, and then of course you have the opportunity to refile for this employee. But if you want him to work from India and don't want to make him pay him H1B salary, you've got to terminate his employment. The second thing you also have to remember that if you're a US company and you have a long arm, what is it called, an arm's length arrangement with an Indian company to render services, then by having employees in India, you might be triggering tax liabilities for the US entity. So you also have to be careful about that. We have one more question that has come. What's your view on the increasing unemployment in the US and its impact on the H1B? Now, I mean, lots and lots of people have been thrown out of jobs, and many of them are in H1B status. Now, there is an organization called the American Technical Workers Organization or Association. I'm not sure I get the correct name, but it's basically an association of American IT workers. They have filed a suit against the government, or they have submitted an appeal to the government. It's an appeal to the government that the H1B program should be suspended for now, because failure to do that will increase unemployment in the United States. So we've got to see what the US government does with such an appeal. But on the flip side, we've got companies that have told us that yes, we may be laying off our people, but we are cutting our accounts team, we are cutting our HR team, we are cutting our XYZ team, but we are not cutting our engineers or our IT workers because we're unable to find those same skills again. So it's going to be better for us to continue to pay their salary and work on new projects than to cut them out. So anecdotally, we are hearing that there is a shortage of engineers and IT workers, but on the flip side, we are seeing that the Tech Association has made an appeal to suspend the H1B program. My suggestion would be we'll all have to wait and watch. Any more questions? Otherwise, we can call it a day. And we just to remind the audience, if any of your colleagues want to join, we are going to do a repeat session like this exactly on the same topic, maybe with some more insights. If there are new developments on Monday at 5:30 p.m. India time, which is 8 a.m. Eastern time. Do join us and do let your colleagues know. We are happy to have them join us and send us your questions. We'll be happy to address them. Thank you for joining, and thank you, Zina, for all your input. Thanks, Rupali, for conducting it.
Thank you, Purvi, and thank you, everybody.
Thanks. Bye-bye.